Now, here's an interesting story. Gert Nel Incorporated Attorneys has launched an urgent constitutional court challenge against a new directive that has been issued by Gauteng Judge President Dunstan Mlambo. The directive, which came into effect last week actually, makes mediation mandatory in the Gauteng Division of the High Court. That's a move that is aimed at addressing a severe case backlog. So before your civil case goes to court, you have to have mediation and a mediation certificate first. Now, Gert Nel, the firm led by the director itself, Gert Nel, is questioning the constitutional validity of the directive, which has sparked strong opposition from both the legal fraternity as well as the public. Let's unpack this a little bit more. Gert Nel, the director then of Gert Nel Incorporated Attorneys, joins us now. Gert, thank you so much for the time. Have I got everything correct there? And ultimately saying that is what the directive is, right? That before you actually head to court or even get a court date, if you do not have a mediation certificate that you try to mediate between the two of you, you will not be allowed to actually have a court date. And you're saying that perhaps the constitutionality of this brings quite a few concerns. Is that correct?
Arabile, yes, that's absolutely correct. I just think the viewers must have regard to the fact that this is a multi-layered result of years of challenges with the Road Accident Fund and the practice directives over the years. Our concern is the reality that since 2000, the Road Accident Fund has adopted the approach that they don't settle in the absence of a trial date. So that has sparked, a movement to try and secure trial dates in an effort to settle Road Accident Fund matters. Now, this is in the context of Road Accident Fund, even though the mediation directive will obviously cover all aspects of the law, all disciplines of law. I'm talking with particular reference to RAF matters.
Yeah.
So, that resulted in a overburdening of the court roles that we are seeing today. And I think added up on that is a special reference to the recent investigation by the SIU, is the fact that the Road Accident Fund also dissolved the litigation or panel of attorneys. So that essentially meant that the Road Accident Fund has been unrepresented in most instances in the courts, and that obviously frustrated the whole court system to such an extent that the practice directives were issued. Now, practice directive is something that the head of a court can issue in order to facilitate the court process or the rules or the act as it is, but it's not intended to frustrate or to prevent litigants from securing court dates. And that's essentially what our constitutional application or urgent application is about, is to try and retain the court dates that we've already secured over the years, because essentially this new directive and mandatory mediation process is implemented retrospectively since the 23rd of April, which means that trial dates that has been secured up until now, unfortunately running into 2031, will be lost subject to this directive.
Okay,
so
I just want to, you've laid on quite a few parts there, and I just want to get into some of them if you'll allow me. Would this scenario not just reduce the number of out-of-court settlements that then happen at a later stage by just avoiding court to begin with? Would we not just have more mediation which gets court cases solved? I understand the portion that you're talking about, that there's trials and dates that have already been appointed that now mean that people may lose those dates. But just to begin with, would it mean that we'd get a few more mediations which are solving these court cases before they even head there?
Arabile, I just want to make something clear. I'm not opposed to mediation.
Yeah.
Our application is purely based upon a question of law and, in terms of the authority that the head of a court has to issue a directive that basically as legislative implications. But the reality is, and I think that is the important aspect of this, it implemented in this directive is the absence of the procedural steps that would be taken. There's an absence of a formal structure that would govern this mediation process and protocol. So what essentially is happening is that the litigants are left to their own accord, meaning that we as practitioners would be faced with a situation that we have to engage, for instance, with the Road Accident Fund, which is or has been found by courts to be a delinquent litigant. So that means that now I don't have any legal power to compel this non-approachable defendant to get him to a mediation process. So my concern is not necessarily the mediation process itself. My concern is there's no infrastructure to accommodate this piecemeal change to mediation. So that essentially means that we as practitioners will have to resort to, or out there on our own, we would have to resort to compel the Road Accident Fund, which, with all due respect, doesn't have the resources or the manpower to accommodate mediation to the extent that is required if we have a look at, or if we take regard to the amount of matters that we're dealing with. So that's my biggest concern. I would rather have preferred that there has been a trial and tested mediation process in place. And I totally agree that that might be a solution to the problem. In my view, there are other means that this could be addressed at far lesser cost and administrative burden to the courts. But obviously, we will deal with that, in due diligence and process.
Okay, so Gert, civil trial dates are currently being allocated. You made note of it. You said this as well to us just now. As far ahead as 2031, which means that it's a delay of around 6 to 7 years before litigants can actually have their cases even heard as well. As you said, you're not opposed to mediation. Should there, and you said that you would have preferred that there be a tried and tested method of doing this mediation process before we just agreed to this. So could there not be additions to this? That what they've put forward right now, not that it isn't okay, but that perhaps more should be added to it, more meat should be added to it, perhaps trial and test the right sort of mediation process first, as you made note of. Should those processes perhaps not be in place first before we then agree to having, or as the court has already agreed, to having mediation as the first port of call before going to court?
I totally agree, Arabile. That is essentially how it should have happened. My concern is the directive is implemented retrospectively, which means that even trial dates at the latter part of this year is already at risk of being lost to victims who have been waiting for years for resolution of their matters. On the 1st of January 2027, all trial dates after 2027 or the 1st of January would be lost to litigants. So, that is our concern. And that would be lost if the mediation process and directive or protocol hasn't been followed to the letter. And again, I wouldn't necessarily have a problem with that, but then there needs to be a soft landing, for litigants to be able to engage on a platform that's being governed by a mediation council, for instance, that would direct how the processes should work, create a database of mediators and facilities that these could be conducted. So, if that was in place, I would totally agree with the process of mediation, because it would definitely result in a larger margin of settlements, and that the backlog that we are seeing currently on the court rolls would obviously be drastically reduced. The question is just then whether the Road Accident Fund is going to have the financial means to address these settlements, on such a large scale.
Very interesting court case, ultimately, this one, and we'll see how things fare. So, Gert, really appreciate it. Thank you so much for joining us then on the show and sharing just your thoughts on this, and as of course having to challenge this court proceeding then as well. Gert Nel, the director at Gert Nel Incorporated Attorneys, mediation being made mandatory in Gauteng civil courts then. So before you even are able to go to a civil court, you